Hello again. All right, we're going to talk about civil liberties. This is chapter 4, and I want to caution you civil liberties is it's a little bit of an intellectually, I think, challenging area of law. Um, not quite as straightforward as some other areas. So I want you to give some extra attention to this. When you take the quiz this week, Federalism and Civil Liberties, I think you'll see there will be more questions on civil liberties than on federalism. I think all of the weekly 3-point questions are on civil liberties. So there's a reason for that. This is an area I really want you to understand. It's important to understanding our constitutional rights. These are all basically embodied in the Bill of Rights. Very important principles to American democracy. I'm following along. I just posted today, Thursday, I'm sorry. Late today, sorry, late this week, sorry. I posted 23 slides on civil liberties. They're there under week 3 now. I encourage you to read them. They will help you hopefully understand the quiz and the material. And I've got the definition here of civil liberties. Areas of personal freedom constitutionally protected from governmental interference, okay, or from government interference. So we have the right to have our free exercise of religion and have that not interfered with by the government, okay? Likewise, we have freedom of speech, freedom of expression, freedom of assembly, okay? Independent from government interference, and we're guaranteed those rights. Okay, it's important for you to keep in mind historically. Remember, we started last week. We were looking at the historical setting at the time the Constitution was adopted. Okay, when the Constitution, as written, the Constitution didn't really. The Constitution itself, before the Bill of Rights, created a pretty strong federal government, and that had some people worried. So almost immediately after the adoption of the Constitution, which that went into effect in 1789, by 1791 we had these first 10 amendments passed, the Bill of Rights. And it's important you understand that the Bill of Rights, as written, they applied to the federal government only. Okay, so they didn't give any rights for people, like if you were a resident of the state of Delaware or one of the other 13 colonies, 13 new states. The Bill of Rights was a protection of you against the federal government. It didn't apply to anything your state did. And that was the way the first 150 or so years of our country, that's the way the Bill of Rights were interpreted, just as against the federal government. Well, beginning actually in 1897, I said in the 20th and 21st century, the first case using this doctrine known as selective incorporation was actually a Supreme Court decision in 1897. Throughout the 20th and 21st centuries, the United States Supreme Court, in a number of decisions, has taken a provision in the Bill of Rights, and if that provision, like free exercise of religion, or the right to be free from self-incrimination, or the right to bear arms, if the court determines this is a right that's so fundamental to our rights guaranteed under the Constitution that we are going to apply this to the states as well, not just the federal government. And the way they do this, one of the important amendments adopted to our Constitution was the 14th Amendment, adopted right after the end of the Civil War. And the 14th Amendment has a very important clause known as the Equal Protection Clause. And that clause guarantees all of us equal protection under the law. And in utilizing this selective incorporation approach, the Supreme Court took the position that, well, if we're all entitled to equal protection under the law, and there's this right guaranteed under the Bill of Rights, it really would be kind of a hollow right if those rights didn't apply if the state was prosecuting us, or if the state was trying to take away some rights. So one by one, those key provisions of the Bill of Rights have been selectively incorporated to apply to the states as well. So I do want you to understand that kind of, I'd even go so far to say kind of somewhat almost esoteric uh, definition of selective incorporation, but make sure you understand that they utilize the 14th Amendment Equal Protection Clause, and if the rights deemed fundamental, then the Supreme Court does that. They apply that they apply that provision in the Bill of Rights to the states as well as to the federal government. All right. Start with the First Amendment. I'm on slide 3 of this 23 slide presentation on civil liberties. The First Amendment is very often regarded as the most important amendment to our Constitution. It contains all kinds of rights, okay? Really 5 freedoms embodied in the First Amendment. I've started with religion, although the Supreme Court has frequently said free speech is the most important right guaranteed by the First Amendment. But let's start with religion in the First Amendment, because there are actually 2 different provisions in the First Amendment pertaining to religion. The first is the Establishment Clause, which says the government cannot establish a religion in the United States. A lot of colonists fled England because there, at the time, there was a mandatory, if you were going to go to church, you had to go to the Church of England, okay? There was a state-established religion. One of the founding principles of the United States was that we would have freedom of religion. You could not be forced to join any religion, so there would not be any state establishment of religion. That's why you see litigation when a public setting, like a government, like a courthouse or a school, a public school, something like that, when they say, all right, well, we're going to have prayer now, and if it's state-sanctioned prayer, that's usually held to be a violation of the Establishment Clause. Notwithstanding that, I mean, we generally public displays of religious symbols if publicly funded, religious symbols are outlawed, but we do have some latitude. I mean, for instance, under God is in the Pledge of Allegiance. The currency says, in God we trust. Notwithstanding those are deemed as kind of neutral statements, and they don't violate the Establishment Clause. In addition to the First Amendment having the Establishment Clause pertaining to religion, there also is the Free Exercise Clause. And that basically just says an employer, the government, and a person's employer or the government, or if you work for the government, both your employer and your government, must make reasonable accommodations to allow the free exercise of a person's religion. Okay, so for instance, I cite this Abercrombie and Fitch case. That's from this century, relatively recently, just a few years ago. A young lady was interviewing for a position with Abercrombie and Fitch, okay, and she was wearing a headscarf, okay? She was a young Muslim lady, okay? And of course her religious practice called for wearing covering her head, okay? And this practice was found to violate Abercrombie and Fitch had this policy known as the look, okay? And everybody had to be with the Abercrombie and Fitch look, and that included you could not wear any hats, okay? Well, when her application was denied, notwithstanding the fact that she was a well-qualified applicant, she went to court and won a ruling that went all the way up to the U.S. Supreme Court that practice violated the free exercise of her religion. It would not have been a big impediment to Abercrombie and Fitch to allow her to wear her hijab. Okay. Likewise, I mean, I also mentioned in this slide there have been cases where penal institutions, prisons, where they require everybody to be clean shaven. Okay. Well, that violates the practice of some religions prohibiting shaving. Okay, and the Supreme Court ruled, hey, this doesn't further any legitimate government interest, there's no reason to not allow inmates to grow beards. As mentioned, free speech is often referred to as the most fundamental right guaranteed under our Constitution. This concept has special protection in the American legal system. It's considered kind of presumptively illegal if there's what's known as a prior restraint. If something in advance says, well, if you say that, you can't say that. Even before you do, you'll be fined, you'll be in trouble. That's known as censorship. And there's a notion that we'll be a better society if everybody can get their ideas out there in the marketplace of ideas, okay? And if there is a rule in advance that says you can't say this or you can't say that, that's what's known as a prior restraint, and those are looked at with strict scrutiny, okay? That's the highest level of review a court can give. And basically, if the court is utilizing strict scrutiny, they say, okay, if anything else, if there's any other way to accomplish your end other than what you're proposing, it's not going to be permissible. So free speech, very important right under the First Amendment. Likewise, and kind of interesting, I've referenced the Citizens United case. This is a relatively recent 2010 decision of the United States Supreme Court. A very unusual, kind of out of an unusual case for the Supreme Court to have decided, because for centuries the Supreme Court took the approach that if you were engaged in political speech or if you were engaged in personal expression, that kind of speech was entitled to greater protection than what the courts referred to as commercial speech. Okay. Speeches that businesses make or that corporations make that are trying to promote their business. Well, the Citizens United case said basically, this involved, there have been laws, and there still are some on the books, that limit the amount of campaign contributions an individual can make. They completely prohibited, prior to Citizens United, corporations from making political donations. Well, in the Citizens United case, the Supreme Court, and this was in a narrow majority, this was a 5-4 decision, it's quite controversial. The Supreme Court equated those campaign contributions made by wealthy individuals and corporations. They said, well, wait a minute, that's speech, isn't it, if they're trying to influence the political process? So they struck down a lot of campaign finance contribution limits, saying it violated the First Amendment rights of those wealthy individuals and corporations who wanted to make the contribution. Opponents of that decision said, wait a minute, the Supreme Court has equated money with speech. And if you follow particularly Democratic politics at all, Bernie Sanders pretty much has built 2 campaigns around it, the idea that Citizens United has to be overturned. Okay, it's seen as giving the wealthy too much influence in their ability to make contributions, and the criticism is, hey, they can buy a campaign. Okay, they can buy a candidate. Notwithstanding, I've got slide 7 here on hate speech. Okay, notwithstanding the fact that the First Amendment is huge. It's way up there in terms of protection. Fighting words, also hate speech, those are outlawed. Those can be subject to limitations. A famous Supreme Court justice from the 1920s, Oliver Wendell Holmes, made the statement once, yes, we have freedom of speech, but that doesn't mean we can run into a crowded movie theater and yell fire. Okay, obviously that would subject people to a lot of danger. Okay, so well, that's not really a fighting word, but you get the point. It's language that could cause injury. So, if you are inciting violence with what you say, if you are subjecting people to danger, that you can be prohibited. Words to the wise: don't ever go on an airplane and say, "Hey, I think I'll put a bomb on this plane." You're going to be in a lot of trouble. Okay. Because again, that's that's potentially endangering the lives of a great many people. Okay, hate speech is a more controversial area. I mean, I don't think anybody would disagree. I don't think anybody has trouble with the notion that you can't make statements that denigrate people of another ethnicity or another religion. That, of course, is not to be tolerated. Where it gets into trouble is sometimes people say, well, wait a minute. Am I just saying I disagree with something, or am I practicing hate speech, or am I just stating my own opinion? Okay, so, but if it's found to be hate speech, you're advocating hatred toward. I mean, there's a movement. Congress, the House at least today passed a piece of legislation to outlaw Asian hate. Okay, we've seen a terrible spike in crimes against Asian Americans, and so Congress is addressing that through a statute. Okay, well, there's no right. Nobody has a right to advocate violence against another person or a group of people based upon, their ethnicity, their religion. That's known as hate speech, not constitutionally protected. Okay, student speech is an interesting issue. Now, with student speech, and this is slide 8, it doesn't apply to us at Clark College so much. Once you're in college, and this is true even for those of you who are running START students and are not yet 18 years of age, the Supreme Court has looked at it and they've said basically, look, if you are a college student, you are engaged in adult activity, okay? When we talk about student speech, we're talking about what happens at the K-12 level, okay? And the Supreme Court has long held, even though schools have the right to keep order, to keep discipline, students don't check their right to free speech at the schoolhouse door. We'll take a look at this Morse versus Frederick case in Chapter 4 that references a kid had a poster during a parade honoring the Olympic torch, and they had a placard that said "Bong hits for Jesus," okay? And it was off school property and it wasn't even during school hours, but the Supreme Court ruled that student could be suspended and subjected to punishment because of the need to regulate activity and not allow illegal drug use. So the limitation of that student's free speech was upheld, okay? Freedom of press, okay, again, a constitutionally protected right under the First Amendment, and the court takes a dim view of any kind of prior restraint, okay, or any type of publication. Even so, though, as the authors mentioned, journalists have still been subjected to arrest and have even been jailed for failing to turn over their sources. Kind of related to the notion of freedom of speech and freedom of press is the tort. When you sue someone for money damages, and it's based upon an intentional act, that's known as a tort. Okay. Well, defamation, either libel or slander, is when a person sues for the tort that they allege that, hey, someone has made an untrue statement about me and caused me damages. When a person makes that type of case, they have filed a defamation lawsuit. Well, one of the limitations on defamation lawsuits is you can't make that. I mean, if the person who is suing is a public figure, if they're a candidate for office or an office holder, they don't just have to prove that someone has made an untrue statement about them and that has caused them damages. They have to prove, in addition to that, they also have to prove that the untrue statement was made by them. The person making the untrue statement did so deliberately. Okay, they knew it was wrong. Okay, if we're just private citizens and I make an untrue statement about you and I thought it was true, that's not a defense. But if you're a public figure, if you're a senator or president, and hey, I had legitimate basis for thinking something was true, then that public figure could not sue me for damages. Okay. I'm going to gloss over obscenity pretty quickly. Obscenity, just keep in mind, okay, when we're talking about freedom of expression, freedom of speech, what's obscene, what's repulsive. That litigation based upon obscenity laws has not fared well because it's just too subjective. How do you standardize what's obscene to one person versus what's obscene to someone else? Okay. The Second Amendment, there were two landmark decisions from the early 21st century involving efforts by some locales to outlaw ownership of handguns in places like D.C. and District of Columbia and Chicago and Los Angeles. And in overturning those handgun bans, the Supreme Court, through selective incorporation, applied the Second Amendment to the states as well as to the federal government. That was the McDonald versus City of Chicago case and the Heller versus District of Columbia case. Fourth Amendment, okay, very important civil liberty rights. Basically, you have the right to be free in your home, on your person, and even in your vehicle from an unreasonable search and seizure by the government, okay? So, generally speaking, when we're in our homes, there are some exceptions to the general rule, but we have the most rights to be free from an unreasonable search when we're in our homes. Okay, I'm in my home right now, so the police can't come in to search my home without my approval generally, unless they have a warrant, unless there are some exceptions. Okay, so for instance, if they see me in plain view, I'm pointing a gun at someone and I'm about to shoot them. The police don't have to wait to get a warrant. They can burst in to stop that crime from happening, okay? If I consent, they say, sure, come on in. I've got nothing to hide, officer, okay? They're permitted to come in without a warrant. And by the way, that's the way the police conduct 90% of their searches, okay? They do so without a warrant. They do so with our consent, okay? In addition to plain view, though, exigent circumstances, okay? It's an emergency, okay? If we don't come in right now, okay? If we don't come in right now, something terrible is going to happen, okay? So we've got exigent circumstances, plain view, or consent. Those are exceptions to the rule that the police need a warrant to enter your home, okay? So, for instance, in Mapp versus Ohio in 1961, the Supreme Court adopted a doctrine known as the exclusionary rule, and they said basically, look, if the police want to come in, if the police sees evidence, and that evidence was seized in violation of your Fourth Amendment rights, okay, then that can't be used in trial, okay? That's what's known as the exclusionary rule, okay? The courts have also, as I mentioned in this slide on the Fourth Amendment, if the police have want to attach a GPS tracker to a person's car, or they want to have a drug sniffing dog go around a car to see, hey, does this person have illegal narcotics in their possession? Okay, well, the Supreme Court has said you can't do that without a warrant. You can't put a GPS tracker on somebody's car. You can't have a drug sniffing dog go around a person's vehicle. Okay, the stop and frisk law in New York, very controversial. A few years ago, it was out. It's no longer practiced after they changed mayors, but under Mayor Rudolph Giuliani and Mike Bloomberg both, New York implemented what was known as a stop and frisk policy, and a lot of civil libertarians pointed, hey, this was nothing more than walking while black. It got referred to that primarily when the police would see young black males, they would subject them to what's known as a stop and frisk. They would check them out and make sure they weren't armed, okay? Well, that was a violation of their Fourth Amendment rights. Okay, let's look at the Fifth Amendment. Two very important rights accompanied in the Fifth Amendment, okay? It's most famous for the right to be free from self-incrimination, okay? If you look at the language in the text on the Fifth Amendment, the guarantee is that a person cannot be compelled to be a witness against themselves. That's what's known as the right to remain silent, okay? In addition to that, though, there's another important clause in the Fifth Amendment known as the Double Jeopardy Clause, which basically says if you've been tried and acquitted of a charge, you've been tried and found not guilty, you can't be tried again, even if they find more evidence against you. Okay. The Sixth Amendment contains a lot of rights relating to the trial of a defendant in a criminal case. Okay. It guarantees, in addition, it guarantees a right to a jury trial. It guarantees a right to a public trial. But what the Sixth Amendment is most famous for is it guarantees the right to an attorney, guarantees the right to counsel. Okay. And in a landmark decision of the U.S. Supreme Court in the mid-1960s in a case called Gideon versus Wainwright, the U.S. Supreme Court held that if a criminal defendant was facing incarceration, they were entitled to an attorney even if they could not afford one. They were entitled to one at public expense if they could not afford to hire one themselves. A very important decision. I don't ask you to know a lot of court holdings by case name, but I will ask you to know a few. If you're a fan of what we used to call cops and robbers TV shows, if you watch things like Cops or Law and Order or you know what, Blue Bloods or whatever, one of those shows, you've probably heard reference to this Miranda decision. Okay, well, there was a 1966 decision of the U.S. Supreme Court called Miranda versus Arizona. That involved the interrogation of a criminal suspect. Okay, so when someone was in police custody here, can George come up? Can we get his head up here? Say hi, George. This is George. He was barking the other day. Okay, all right, but he's not going to bark today, are you, buddy? No. Well, Miranda versus Arizona, the Supreme Court said when a person is in a custodial interrogation, a person in a custodial interrogation, okay, meaning you're in police custody, okay, the police cannot use any statement the person made if they have not been advised of their rights, okay. These rights there are 4 of them, okay. You must be advised that you have the right to remain silent. Okay. In addition, what are the consequences of waiving that right? If you waive the right and you speak, anything you say can be used against you in court. Okay. And then the next 2, you have the right to an attorney, and finally, if you can't afford an attorney, one will be appointed to you at public expense. Okay. You've probably heard of the Miranda warnings before. Like I said, if you're a fan of any kind of televisions or movie shows television shows or movies that feature criminal activity, okay? 7th Amendment, not too important. The 8th Amendment, okay, focuses on cruel and unusual punishment, okay? And for the most part, when we look at cases under the 8th Amendment, those involve capital punishment, okay? It's worth keeping in mind 2 points on capital punishment, okay? It is still an allowable penalty, and it's constitutionally permissible in the United States. However, you'd be remiss if you did not realize that support for the death penalty is decreasing in this country pretty dramatically, actually. When I started teaching at Clark in 2001, there were 38 states out of 50 that had the death penalty. Today, that number is down to 27. Washington was a death penalty state until a few years ago. It was abolished by our state Supreme Court. Virginia just became the 23rd state and the first state in the South to outlaw the death penalty. There have been concerns there have been a lot of people who have been cleared by DNA evidence or witnesses recanting testimony. So the fact that there have been erroneous convictions, that is one mark against the death penalty. The other is that it's always been argued by legal scholars that it is not applied in a race-neutral way. So that's caused support for the death penalty to decrease. And it's worth keeping in mind we are the only Western democracy. All of Western Europe, Canada, Australia, all of those democracies have outlawed the death penalty. Okay, of G7 countries, okay, only the United States and Japan still allow the death penalty. Now, in addition to those are specific amendments under the Constitution, there's also the right to privacy, okay? A key issue in American jurisprudence and in politics involves whether or not abortion should be allowable. Well, since a 1973 ruling in a case known as Roe versus Wade, okay, uh, abortion has been or terminating a pregnancy has been a constitutionally protected right of a woman, okay? Where did that right come from, okay? Well, the Supreme Court said you take all the rights that emanate under the Constitution, and those amount to we have a right to be left alone in America, okay? And if we didn't have the right to be left alone, taken all together, that involves a right to privacy. It's somewhat controversial because you look at the language of the Constitution and you never read the term that there is a right to privacy. But before the Roe case, there was a 1965 case called Griswold versus Connecticut that said a couple could not be a married couple had the right to obtain contraceptives if they so desired, and it was an unlawful invasion of their privacy for a state to attempt to outlaw that right. Okay. Other decisions based upon the right to privacy. In 2003, the Supreme Court, in a case called Lawrence versus Texas, outlawed what were known as anti-sodomy laws. Basically, the crime of two same-sex people engaging in sex. And as the Supreme Court said at that time, look, you're outlawing somebody's status for being a gay person when you have a statute like that. So that's not constitutionally permissible, okay? And as the dissent noted, the dissent of Justice Scalia said, well, look, if you make this decision, you're also going to eventually be allowing same-sex marriage, and within 10 years, that's what the Supreme Court did in the Obergefell versus Hodges case, okay, and some other U.S. versus Windsor or New York versus Windsor as well. Physician-assisted suicide, which is permissible in Washington. Actually, Oregon, our neighbor Oregon, was the first state in the country to have what's known as a death with dignity law. But physician-assisted suicide is, again, based upon the right to privacy. And Oregon, when they adopted theirs in 1999, they were ahead of the curve. We now have something like 12 or 15 states that have physician-assisted suicide laws on the books, okay? These laws basically say if someone has a terminal illness, two doctors have verified that death is likely to occur within 6 months, they're of sound mind, okay, they can seek a prescription of a lethal combination of drugs that will end their life, okay? The law has two mandatory waiting periods in it, okay? First one is 15 days, the second one is 48 hours, okay? And incidentally, Washington adopted the Death with Dignity Act in 2008, okay? But Washington's law was closely based upon Oregon's. There was actually a United States Supreme Court decision on the Oregon physician-assisted suicide law, and the United States Supreme Court upheld that as constitutionally permissible. So that makes it highly likely if there was ever a challenge to Washington's physician-assisted suicide law based upon this stare decisis ruling of the United States Supreme Court, that would be upheld. Okay, so keep in mind though, on the Death with Dignity Act, okay, we don't allow euthanasia. Okay, euthanasia or mercy killing would be allowing a third person to put someone else to put somebody to death. So your doctor cannot give you a lethal injection to end your life. Okay, another person can't, suffocate you or do some other kind of affirmative act to end a person's life. Okay, that would be murder under our laws. Okay, so but physician-assisted suicide says a person can take a prescription and do so in a way to end their life. Okay, and that again is based upon an independent liberty. Okay, the right to control one's health. Okay, so those are some of the primary issues involved in civil liberties. Okay, so thank you very much.